the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. I'm sorry, Your Honor, I meant to gavel in first.
That's all right. I think we're now in session. So good afternoon and welcome to this remote oral argument session of the North Carolina Court of Appeals. We have one case on the calendar this afternoon, and that's number 2193, Munoz v. Munoz. This case was a participant in the North Carolina Appellate Pro Bono programs. We'd like to thank counsel for appearing pro bono and participating in this program to allow us to have this orally argued case. I'm Richard Dietz, so joining me on the panel today are my colleagues, Judge Valerie Zachary and Judge April Wood, and we've confirmed that the parties are ready to proceed, so we'll hear from the appellant.
Good afternoon. May it please the court, Judge Dietz, Judge Zachary, Judge Wood, my name is Alicia Journey, and I represent the defendant, Cassandra Munoz, in this case, and I would like to reserve 5 minutes of my time for rebuttal. This case arises from a permanent child custody order that was entered in an action between Ms. Munoz and her husband, Mr. Munoz, in Cumberland County District Court. The order that brings this appeal is a permanent custody order that was entered on August 20th of 2019. For two reasons, we will ask the court to reverse and remand the order for further proceedings. The first reason is that we believe the trial court abused its discretion by improperly considering Ms. Munoz's military service obligations in violation of North Carolina General Statute 50-13.2 subsection F as a negative factor in its decision to award custody to her former husband, Mr. Munoz. And the second reason is because we believe that the court abused its discretion by failing to consider the factors set out in Ramirez Barker versus Barker in order to determine that relocation to California for the minor child in this case was appropriate. So as to the first reason, I'll go through a little bit of the procedural background because I think it's significant that Ms. Munoz's history and her experience in this case is similar to those of service members across the state of North Carolina who will likely be impacted by the court's decision in this case and its interpretation of subsection F of 50-13.2. Ms. Munoz is a member of the United States Army. She joined the military in July of 2012 when she was only 17 years old. At the time of the trial in this matter, she had been in the military for 7 years on active duty. Throughout the parties' marriage, she'd been stationed at a few locations. The parties were married at the end of 2012 when they lived in California, which is where they were both from. She then moved to Virginia, then to Hawaii, and then moved to North Carolina, I believe, in 2016. The party's daughter had been born a year earlier. Her name is Mila, and she was 4.5 years old at the time of this action. So Ms. Munoz was in the military. The parties were in North Carolina as a result of her military service. Mr. Munoz's family would remain in California. The parties had been having difficulties in their marriage, and they decided to separate in 2018. Around the same time they were discussing separation in early 2018, Ms. Munoz learned that she was going to be deployed to a combat zone in Iraq in around May of 2018. So, procedurally, in this case, Mr. Munoz filed this action at the time that he and Ms. Munoz were still living together. He served Ms. Munoz with a complaint in mid-April of 2018, and the temporary custody memorandum of judgment was entered with the consent of the parties in early May of 2018. And at the time that memorandum of judgment was entered, it was the expectation of the parties that Ms. Munoz would be deployed. And so the memorandum of judgment essentially allowed Mr. Munoz to move to California on a temporary basis as he wanted to with a minor child so that his family could assist in caring for her during the deployment. Shortly after this order was entered, Ms. Munoz learned that her deployment was going to be delayed. And so originally it was pushed back to June of 2018, then it was pushed back to July of 2018. There were several motions filed, several review orders entered to address custody in the interim because the parties had originally believed that Ms. Munoz would be deployed. Mr. Munoz attempted to move before she was deployed. There was some litigation between the parties related to that. And eventually there was an order that was entered that required Mr. Munoz to remain in North Carolina with Mila until July of 2018. And so procedurally, I think it's important to remember that the order was entered with the expectation that Ms. Munoz would be deployed for 9 months. At that time, she expected that she would be in Iraq and unable to exercise custody of the party's daughter until she returned 9 months later, and that shortly after she returned, there would be a custody trial that would address custody on a permanent basis. Eventually, Ms. Munoz's deployment went from getting delayed to being canceled altogether. But there was already a temporary order that was in place that had allowed Mr. Munoz to relocate with Mila. So she was stationed here under military orders and unable to move, and her daughter and Mr. Munoz's daughter was in California across the country. There were several delays in this custody action, which is not uncommon in child custody proceedings. The trial had been scheduled, I believe, initially for the end of November, so November of 2018, when they learned that Ms. Munoz would not be deployed. It wasn't reached in November of 2018, so it was continued to June of 2019. It wasn't reached in June of 2019, and so then it was continued to August of 2019. And there were a few review orders that were entered in the interim. So eventually there was a custody trial that occurred in August. Oh, I'm sorry, Judge Zachary.
Well, I was going to wait for you to finish, but since you stopped, I'll ask you, did you, are you contending that her possible future deployment was the only basis for the trial court's determination that it would be in the child's best interest to live with father in California?
Yes, Judge Zachary. Well, to be clear, I don't think it was
basis.
I don't think it was the only basis, but I do think that it was the primary basis. And so if you look at the findings that the court made in the order, and I believe that it begins on page 69 of the record, and the findings are quoted, I believe, on pages 19 and 20 of the appellant's brief. Excuse me, I was 21 and 22 is where the findings about her military service are. So I don't think it was the only reason. I think it was a significant reason. And I think if you read through the trial court's findings and you consider them as a whole, then it becomes clear that it was the deciding factor. So
but is that what the statute says? Because the statute seems to explicitly anticipate. I mean, what it says is a court may not consider a parent's past deployment or possible future deployment as the only basis in determining the best interest of the child. So how do you reconcile the statute with the argument you're making to this court?
Yes, Judge Zachary. So I agree with you that that's exactly what the statute says, but I don't think it's entirely clear whenever you read it in conjunction with a comment to the statute, the official commentary. So when this was added in 2013, subsection F was added, there was not only the statutory language that you just quoted, but there was also the official comment. And this is quoted on page 19 of the brief. And it basically says subsection F prohibits the court from using a parent's past deployment or possible future deployment itself as a negative factor in determining the best interest of the child. However, the significant effects on the child of the parent's past or possible future service may be considered. The term significant is meant to exclude the courts considering trivial impacts of a parent's deployment, such as the need to enroll a child in a different school. Under this standard, the court may only consider impacts that are substantial or material. So I think that when you look at the comment and when you look at the language of the statute, that it's not entirely clear. I do agree that the statute says exactly what you quoted, that it can't be used as a primary basis. But I think whenever you get into the commentary, it becomes a little bit less clear because the commentary says that it can't be considered as a negative factor. And I think if you look at the title of the statute when it was amended, where it says consideration of military service, then, I mean, it's potentially even broader than just considering the deployment, the act of deployment itself.
But didn't the court also consider the opportunities, didn't the court also make a comparison of the opportunities available to the child in California as opposed to North Carolina?
So no, I don't think the court actually made a comparison. I think the court was required to make a comparison. I think that's what the decisions of this court have said, that a court essentially has to make a comparison between the opportunities and the interests of the child in North Carolina versus the opportunities and the interests of the child in California. I think the court recited some things that that would be consistent with the child's life in California, such as that Mr. Munoz lived with his family, that she would be cared for by a third party, by Mr. Munoz's grandmother, and that she would be near his family. But the court didn't really do a comparison, because some of the things that the court recited are not self-evident. And I think the court addressed a very similar situation recently in the case of Toole versus Toole, which was a 2020 decision. This was just from last year. And it was actually cited in the appellee's brief. But in the Toole case, it was very similar because it focused on the support system that that the mother had, I believe, in Indiana in that case. And the Court of Appeals, the panel in that case said that it was clear the primary reason for the court's decision to allow the relocation of the child from North Carolina to Indiana was because of the support system the mother had in Indiana. And that was not sufficient to meet the requirements of the Ramirez-Barker case in doing a true evaluation of the best interests of the child. And so there are a lot of things.
In Toole, it really wasn't clear that mom actually had that great of a support system in Indiana too, wasn't it? I mean,
That's true.
Well, but they also, in this case, the trial court also considered the fact that in California, the child was able to take swimming lessons and taekwondo, and the school was, within walking distance. And, whereas in North Carolina, the child would be in daycare for 11 hours a day. Why is that not a comparison between the opportunities available to the child in the two states?
Because it doesn't really address the impact on the child. The court recites what the child's day would be like in California versus what the child's day would be like here, but it doesn't do a full comparison. Specifically, if you look at all the factors the court's required to consider, it goes a little bit to the first factor, which is the advantages of the relocation in terms of its capacity to improve the life of the child. So to your point, Judge Zachary, she would be able to take taekwondo and swimming lessons there. But Ms. Munoz's testimony was that here, she would have her enrolled in preschool and daycare, and she would be able to do things during there. And it doesn't really address what I think is, it goes to the first factor and also the fifth factor, which is the likelihood that a realistic custodial schedule can be arranged, which will preserve and foster the parental relationship between the child and the non-custodial parent. And that is that you have a service member who's required to remain here in North Carolina. You're allowing a 4.5-year-old child to relocate to California. And there were findings in the order specifically about the strong relationship that this little girl had with both of her parents. And so even though there was a recitation of things that she might be able to do during the time that the mother was working, it wasn't really a comparison of how that would affect her life and why those things were more beneficial than allowing her to remain here, which would have allowed her to preserve a relationship with her mother. And so to your point about the work hours, which, well, not exactly your point, but it goes to the point about the work hours of the parents. So this little girl was going to be in the care of her paternal grandmother, her paternal great-grandmother. I think it was Mr. Munoz's grandmother. And so Mr. Munoz testified, there were no findings of fact in the actual order about his work hours. There were findings of fact about Ms. Munoz's work hours as a service member. But if you look in the transcript on pages 46 and 47, it goes to Mr. Munoz's work hours, and they're essentially the same on many days as Ms. Munoz's. So he says his typical work hours are from 9 a.m. to 5:30 p.m., but on some days he works from 6 a.m. to 6 p.m. Ms. Munoz testified, and the trial court found in its order that taking into consideration PT, her work hours were from around 6:30 a.m. to 5 p.m. So there was essentially the same amount of time that each of the parties was going to be spending away from Mila. And they were each going to be relying on third parties to take care of their daughter during the times that they were working. The only real difference there is that it would be a third-party great-grandmother versus a third-party childcare provider, and that Ms. Munoz's obligation to work was as a service member as opposed to Mr. Munoz's obligation to work as a UPS worker. So they were both going to be spending a lot of time away from Mila, and I think that's one of the things the trial court didn't do a comparison of, why it was beneficial for the child to have time away from one parent in the care of a great grandparent as opposed to being in the care of another child care provider where she could have other types of opportunities. So, and I think that's how I think the first point and the second point are really related in terms of the trial court's abuse of its discretion, because you have the improper consideration of Ms. Munoz's military service, and it does relate to some of the factors in the Ramirez-Barker case. I've touched on the first one.
But aren't those the kind of decisions that we task our district court judges with making in custody cases? And is it really appropriate for this court to, to make that kind of determination?
They are, Judge Zachary, absolutely. And an abuse of discretion is a very high standard for an appellant to meet. And Ms. Munoz is not asking this court to substitute its judgment for the judgment of the trial court, but there are limitations that are placed on the trial court's discretion. In this case, there's been a limitation that's been statutorily placed by subsection F of 50-13.2 in terms of the court's ability to consider a parent's military service. And then there are other requirements for the court to consider, limitations that have been placed on the court's discretion by the decisions of this court, which have established factors specifically related to relocation cases. And so I think even though it's criticizing the trial court's decision-making or analyzing it and critiquing it, it's not substituting this court's judgment for that of the district court to make sure that the trial court is exercising its judgment appropriately. Because
So is your,
sorry.
I'm sorry, is your argument that on the factors, the trial court's findings are not sufficient to support its conclusions, or that there was evidence that would have compelled findings about relevant factors and the court failed to make findings on those based on the evidence in the record?
So Judge Dietz, it's actually both. So I think there was evidence presented about some of the factors that the trial court did not make. And I think the court, whenever there's evidence that's presented related to those factors, the court's required to consider them and make findings about them. And it's impossible for this court, acting in its role as an appellate court reviewing the decisions of the district court, to determine whether the court gave those appropriate consideration without any findings being made. And so number one. And number two, I do also think that the findings that are contained in the order are insufficient to support the trial court's conclusion that relocation was in the minor child's best interest. Because if you look at the findings in the order, while they do accurately reflect what the child's life is like and the procedural history of the case and the employment of the parties, they don't really address the impact on the child. They don't really address the impact of each of the things that it's making. And I think, so in the Toole case, in the Evans case, the court has said that you can't just make these findings, especially when things are not self-evident, and have those be sufficient to show that the court considered the impact on the child in determining what the child's best interest was. And I believe, so I went through this much more exhaustively in the briefs than I will probably have time to do it today. But there were several things that the court made, that there was evidence presented about that the court failed to make findings about. And so that in the brief, those things are listed, they begin on page 15 and I think go through page 17. So the court didn't make findings about Ms. Munoz's family support system here in North Carolina. There was a reference to family that lived in the state but 3 hours away, but they didn't make findings about the history that Ms. Munoz's family had in taking care of Mila and the support system that she had here, particularly since Mila was originally supposed to be living with Ms. Munoz's family members whenever whenever Ms. Munoz deployed before Mr. Munoz filed his custody action. There was significant evidence about the difficulty that Ms. Munoz had in contacting Mila since she moved to California with Mr. Munoz, including trying to reach her by phone, Mr. Munoz returning to North Carolina and not bringing Mila with him, so Ms. Munoz would be able to see her. And I think that goes to the fourth factor, or excuse me, the third factor, which is the likelihood that the custodial parent will comply with the visitation orders when he's no longer subject to the jurisdiction of the courts. There is Cassie's plans to have Mila attend preschool and the benefits that she thought that would allow her to have. And probably most significantly, and this is where it kind of goes back to your question earlier, Judge Zachary, the probable negative effects on Mila of being so far removed from her mother. If you look at the custody order that was entered and you look at the court's findings about each of the parents, Ms. Munoz ended up with only 20% of the time with her daughter. And this is from two parents who the court found were both good parents, didn't make any negative findings about their parenting ability. Oh, I'm sorry, Judge Zachary, I'm not trying to talk over you. It's hard for me.
No. I was waiting for you to finish. But you know, and please correct me if I'm wrong, but didn't the mom ask for a certain amount of time and the court gave her the amount of time that she asked for?
So actually, no. And I believe, I'm sorry, I don't know exactly where this is in the transcript, but there was, I believe the mom actually testified about how she had leave saved up. She had saved up her leave so she could spend time with her daughter. And she requested a certain amount of time to spend time with Mila, and the court didn't even give her the amount of time that she requested, even though she hadn't seen her, I believe, since February at the time the order was entered. And
but that's not in the permanent order though, right? That's not in the permanent custody order. Aren't we talking about earlier in the case, as I recall?
So what I was referring to was the permanent order at the time that the permanent order was entered. I believe when the temporary orders were entered, and if I'm mistaken, I apologize, but I believe at the time the temporary orders were entered, Ms. Munoz's expectation was still that she was going to be deployed. And so she had requested, I believe you might be thinking about, let me see if I can get this right. I believe you might be thinking about an order that was entered, and it gets a little procedurally confusing because there were memorandum of judgments entered and then some formal orders that were entered after new orders were entered, where she believed that she was going to be deploying in July, and she had requested, this would have been July of 2018, and she asked for the court to allow her to spend until July of 2018 with Mila. And so then there was an order that was entered to that effect. And then this was right after the case was not reached in November of 2018. And so this is a memorandum of judgment. I think it's on page 55 of the record. But so the case was supposed to be heard on November 29th. It didn't get reached on November 29th. So the parties entered into a memorandum of judgment providing for holiday visitation. And that was subsequently entered as a formal holiday visitation order on January 7th of 2019. And at that time, again, the parties thought that, I believe it might have been earlier, but definitely there was a trial that had been scheduled in June of 2019. So they thought that it would be addressed by the court relatively soon. So all of these were sort of Band-Aids that were put in place along the way to address visitation until Ms. Munoz could get back into court to address custody on a more permanent basis.
But when was she denied extra visitation? Because my understanding is that in the permanent order, she got what she asked for.
So I believe in the permanent order that she had asked for Mila not to relocate, that she had asked for Mila to remain in North Carolina. So in terms of the visitation schedule, she wasn't even seeking long distance visitation at that point. She was asking for primary custody of her, for Mila to live with her. Mm-hmm. And I believe
But in the alternative, did she ask for a certain amount of visitation?
And I don't recall, honestly, what the visitation schedule was at that point, if there was a specific schedule that she had requested. What I do recall is there was some discussion that's in the transcript. And maybe while Mr. Yes, ma'am.
Perhaps there's just a little confusion, but are you talking about her 45-day leave period that she was talking about at the end, and then there was a week that was given to her in the final order because the child was getting ready to start school?
That's correct. That's correct, Judge Wood. That's exactly what I was talking about.
So, okay, I just want to make sure that I was on the right page here.
Okay.
Thank you.
Okay.
Thank you.
Thank you. Yes, that's what I was talking about. I'm sorry.
So if we suppose we believe that your statutory argument about 5013.2F fails because there was enough other findings, and then we also believe that the findings that the trial court made would be sufficient under our case law to show that the court considered the factors that are sufficient to support its conclusion. Is it enough to say there was evidence about what I'll call like counter factors, and the trial court didn't make findings about that? Is that a reversible error, or is it that we need to be able to say the court didn't consider that evidence, although it may have considered it and just found that the findings it needed to make to support its conclusion were the ones that are contained in the order? Does that question make sense to you? I'm trying to figure out if that's reversible error, not having specific findings of these other factors.
I think it does make sense, and I'll answer the question as I understand it to be. So yes, I think that when there's evidence that's presented about these factors related to relocation, the specific factors that have been enumerated in Ramirez Barker and Evans and Toole and several other cases of the Court of Appeals, and the court doesn't make findings even addressing those factors, then it is reversible error, because there's no way for the court to determine whether the court actually considered those factors or not and made the comparison that it's required to make between allowing the child to remain here and allowing the child to move to another state. And it appears that I'm down to 4 minutes. So unless there's other questions, I would like to reserve my time for rebuttal.
All right, thank you, counsel. We'll hear from the appellee.
Thank you, Judge Dietz, and may it please the court. I'm Chris Edwards, and I represent Isaac Munoz, and we are here today to ask that the court affirm the trial court's order awarding Isaac primary physical custody of his daughter, Mila. I want to start very briefly by touching on this subsection F issue. As I understood Ms. Journey's argument, there's been an admission that the trial court's findings do not violate subsection F. The plain language of that statute is pretty clear that it only matters if the trial court relies exclusively on a parent's potential future deployment or past deployment when it renders its best interest determination. And here, I think we would dispute first that the trial court considered potential future deployment at all. It did consider what I would call the more mundane aspects of any job, not just military service, but service that law enforcement or first responders, what have you, would provide. That is, long work hours. But even if the trial court did consider deployment or military service, I don't believe that it was the only factor. Now, Ms. Journey has made the assertion that the statute, as I understand it, the claim is that the statute is ambiguous by pointing to the comment and to the title. Our Supreme Court has said that the best intent of the legislature is the plain language of the statute that it enacts, and I think that the word deployment is self-evident there. I don't have a Black's Law dictionary definition of it, and I apologize for that. But I do think that means, leaving to go serve overseas or being restationed, what have you. It's got to mean something more than just waking up early, going to PT, and then coming home late at night at the end of the workday. Even if the court were to conclude, however, that the plain language of subsection F is ambiguous, I think if we look at the title and the comment, one of the things that is most instructive is probably reading the statute in context. Subsection F was passed as part of a larger package in Session Law 2013-27. Our General Assembly passed in its entirety the Uniform Deployed Parents Visitation and Custody Act, and that statute kind of as a whole speaks to deployment and the unique situation that that puts trial courts and parents in. So the remainder of that statute was codified in Section 50A of the General Statutes. And if you look at Parts 2, Parts 3, and Parts 4, which we cite in our brief, it gives you kind of an overview of the custody process. So first, there are provisions allowing for temporary custody agreements between parents when one of the parents is about to deploy. There are also provisions allowing for expedited custody proceedings when one of the parents is about to deploy if the agreement fails. And then finally, there's a provision allowing the parents to undo all of that once the service member parent returns. When you read subsection F in the context of the entire statute, then it seems to me that the statute is actually intended to allow parents to work out in real time what's going to happen with their child while one parent leaves and is overseas serving their country. And then when that parent comes back, there's an understanding, a policy understanding by our General Assembly that a trial court won't look at that parent's deployment as I guess you call it a history of absenteeism. Saying, look, you've been gone for 8, 10, 24 months. You can't be a good parent. We've kind of set that outside the bounds of what our trial courts are allowed to consider when rendering permanent custody awards. So here, I think that the trial court did exactly that. It never considered, it never mentions Miss Munoz or Cassie's potential future deployment. I'd note that by
Mr. Edwards, let me just ask you real quick then, if in light of that statement, how do you reconcile the fact that finding of fact number 28 says, while she ultimately did not deploy, she remains in the Army and is subject to deployment or reassignment at any time? Doesn't that sort of seem that the court was considering that she might deploy and she might not be available to care for the child in the future?
I don't think so, Judge Wood. As I understand that finding, it's just kind of a descriptive finding about Cassie's job. And in that, read in that light, it's not saying, none of the analysis says that Cassie is likely to deploy in the future and that therefore Isaac should be awarded permanent custody. I do think, and assuming that that finding means, as you suggest, that the court's considering Cassie's potential future deployment to some extent, I think the other findings, when we look down at page 71 through 73 of the record, contain some really meaty findings about what Mila's life is like in California and comparing that with what Mila's life will be like in North Carolina. And that's kind of a good segue into the Ramirez-Barker factors, because we believe that the trial court appropriately considered all of the material factors in this case, and it made its decision based on the material facts that were in the record and based upon a consideration of what was in Mila's best interest. So the Supreme Court's said that the polar star of any child custody decision has to be what is in the best interest of the child. This court has adopted kind of a longhand format for that in 5 factors. So does the potential relocation have the capacity to improve the child's life? The second and third factors address the motives of the parent in opposing or seeking relocation. The fourth factor is whether the custodial parent's going to abide by the custody schedule adopted by the court, whether he or she's going to abide by the visitation schedule. And then finally, there's the realistic opportunity to maintain the parent-child relationship between the child and the non-custodial parent. And I think that many of the trial court's findings address the best interest of the child through the lens of that first factor. There's been some discussion of the Toole case and of the Evans case, and we don't think that either of those cases control here. Looking specifically at the Toole case, Judge Zachary, your point, the case addresses entirely a family support system. And I believe this court says, first off, as it did in Evans, the analysis is supposed to focus on the child and the child's life, not on, is this going to be easier for mom or is this going to be easier for dad if there's a relocation? I don't think that that's an irrelevant factor, but the primary thrust of the analysis needs to focus on the child. And so in both Toole and in Evans, this court was faced with a child custody order where the trial tribunal had said in Toole, look, there's going to be plentiful child care, but it never actually analyzed what was available to the child. And then in Evans, I believe the entire analysis was based on the father-son relationship. The trial court, I believe, actually said that this young boy needed to be close to his father. Judge Wood, do you have a question?
No, go ahead.
I'm sorry, you lit up.
I was getting ready to ask a question, but I'll save it for later. Go ahead.
So in this case, instead of comparing just support networks, the trial court actually makes these findings, and I think there are four that are pertinent. The first is that in North Carolina, Cassie works all day, 5:30, sometimes 12, 13 and a half hours a day, and that would result in Mila being in daycare. So the upshot of that is that if Mila had stayed here, she would have been in daycare for many hours. Sometimes I think it's as many as 60 hours a week. Now, I understand the appellant's point that Isaac does work long hours, and that's true, but the support system that he has in place in California, the support system that can help care for the child, it's not just about Isaac's grandmother and Mila's great-grandmother being there, but it's about the opportunities that she opens up to Mila as compared to the opportunities she would have in North Carolina. And so there are factors suggesting that, you know, she's participating in sports, she's participating in swimming lessons, and that really goes to the ultimate goal of a child custody decision that this court articulated in Frey against Best, that we're looking for something that can grow the child mentally, emotionally, physically. It's those type of opportunities that the child has to kind of become a more well-rounded person. And that there's just no evidence in the record that she would have had those same opportunities if she had stayed here in North Carolina. I note that Cassie does take offense or objection to this idea that her parents aren't there to play a role in the child's life. But
Let me ask you a quick question about that, Mr. Edwards, because the court did make a finding number 29, that says the truth is they've never parented the minor child completely on their own, either together or alone. They've always had family support, and Mila is fortunate to have such a great supportive family system on both her mother's and father's side of the family. So there had to be some evidence that there was family support.
There was I'm sorry, Judge. There was historical evidence of family support. So for a period of time, Cassie's grandfather had lived with Isaac and Cassie, helping to raise the child. And I think that there was evidence that Cassie's mother and stepfather, so Mila's maternal grandparents, did have some level of involvement, and they were supportive. But the evidence also showed that they were supportive, but not in a position to be readily available, such that it would affect Mila in real time. So Cassie's parents, or Cassie's mother and stepfather, live in Asheville, Cassie's in Fayetteville, and the unobjected to findings, that's 3 hours away, and I believe the evidence presented at trial or at the hearing shows that they only saw Mila maybe once or twice a month. Obviously, they were willing to make arrangements for Mila to come live there long term, but I don't think there was anything in the record showing that they were willing to kind of take on this day-to-day management, and that's or provide day-to-day help for Mila that would have moved her out of that daycare setting and given her access to the same type of opportunities that she had. You know, grandma couldn't walk her to school. Grandma couldn't take her to taekwondo or swimming lessons in North Carolina because of that distance. Meanwhile, in California, that's exactly what grandma's doing. And Mila's all the better for it because it's, again, helping round her out as a person, giving her that emotional, mental, and social engagement that she needs to grow and develop. Turning from the first factor to the remaining factors, and Judge Dietz, I think that your question to Ms. Journey is a good one. Do there need to be findings? Do there need to be kind of counter findings? I think the answer is no. Again, if the goal here is to find the best interest of the child, to find the placement that would make the child best off, I think the trial court does need to consider the evidence in front of it, but doesn't necessarily have to make these counterfactual, or it's not these counterfactual findings, but these positive and negative findings.
Mr. Edwards, let me ask you a quick question. The order itself reflects that North Carolina was the home state, but several times talks about the child residing in California with the father at this time. So where do you contend that, as Ms. Journey pointed out, the court made the necessary findings in Ramirez Barker versus Barker, which talks about whether or not a relocation would be in the child's best interest?
I think the comparison of Mila's life as lived in California versus North Carolina, this is a little bit unusual, I think, in that the relocation occurred pursuant to two memoranda of judgment and in these interim orders. But what actually happened is, by the time of the permanent custody hearing, the court had actual evidence. It's not just evidence about the capacity to improve Mila's life, but the court had actual evidence of the improvements that Mila's life had versus what Cassie kind of admitted in her testimony Mila would have had if she had remained in North Carolina. So you've got proof of Mila of Mila participating in swimming lessons and taekwondo, as compared to the admission that she would have been in daycare for a long time, and the trial court's, I think, well-supported findings that Cassie's mother and stepfather wouldn't have been able to participate in Mila's life on a daily basis and alleviate some of that, and alleviate sort of that monotonous day-to-day existence of just being in daycare. Looking at the other factors, I don't know, as I said earlier, that the trial court was required to make findings on those. It wasn't required to weigh them, where it ultimately concluded that moving to California was in Mila's best interest. Even if it were required to address them, I think that in some cases this court has suggested that they only come into play when there's relevant material evidence on each of those factors. And if you look at the transcript as a whole, we would contend that there's not material evidence on any of the remaining factors. And to the extent that there is, I think that the court satisfied its burden to explain itself. As far as the second, what I've characterized as the second and third factor, and I think in Ramirez Barker, it's the second and fourth, which are the motivations of the parents. I don't think there can be any dispute that Cassie has a good motive for opposing the relocation. She's unable to leave North Carolina, and you know, we have to concede that. She's here on military orders. But Isaac, as he explained to the trial court, his desire to relocate wasn't to take Mila away from Cassie. It was to return to his strong family support system in California. So I think both parents have honest motives there. Regarding the factor about the likelihood that the custodial parent will adhere to the visitation schedule, I don't think there was any material evidence on that. In her brief, Cassie raises 2 points. First is that there had been some difficulty contacting Mila, and second is that Isaac would not bring Mila back for the permanent custody hearing. I don't believe that either of those arguments reflect Isaac's unwillingness to participate in the court-ordered visitation schedule. Again, bringing Mila back for the hearing, as Isaac testified, was expensive, and it was not required by the court order that was in place. So Cassie's complaint in that regard is that Isaac didn't go far enough in exceeding the court's order. Now, with respect to the calls that Cassie says were interrupted, I think the evidence in the record shows that for a period of time, Cassie was calling every day and at different times. And even later, she was calling kind of at different days of the week. There was no set schedule. And she always called at a different time. She would call between, she said, 7:30 and 10 o'clock, or 8:30 and 10 o'clock Eastern time. And so in California, she's trying to reach out to speak to her minor daughter between 5:30 and 7 local time. So naturally, I think there are going to be some occasions where there are missed calls. A child of that age at 4.5, 5.5, 6 is eating dinner, might be outside playing. There are a number of innocent, innocuous explanations for that. And I would contend that the evidence submitted to the trial court does not reflect that Isaac was actively interfering. Now, as to the realistic visitation schedule, I think that's one of the more interesting features. The trial court, all told, gave Cassie 10 weeks out of the year. In some weeks, she has 11 weeks, or in some years, she has 11 weeks, including the week of Thanksgiving. So she gets the week of Mother's Day, she gets the week of spring break, she gets 7 uninterrupted weeks in the summer, and then she gets Thanksgiving in odd years, and then about 10 days around the Christmas holiday. And that alternates, whether Mila spends Christmas with Cassie or with Isaac, alternates from year to year, but she always gets her either at Christmas or at New Year's. Point in saying that is this: I haven't found a case from this court or from our Supreme Court addressing what a realistic visitation schedule means. But if the court looks at the D'Onofrio case, which is the New Jersey Chancery Court that the Ramirez-Barker court cited in adopting these factors, so this is kind of the original source material, the court explains that the realistic schedule really means several uninterrupted weeks of custody per year. And that's exactly what we have here. As the D'Onofrio court explains, that is better for the child and for the parent than maybe even weekend visitation, because it's not just keeping the child for 2 to 3 days, but it's actually having the opportunity to parent, to plan out the child's day, the child's week, or over the course of the summer, the child's month. So Cassie's getting that opportunity in spades. In just a few weeks, Mila will be coming to North Carolina pursuant to the schedule set out in this order. She'll be spending 7 uninterrupted weeks with her mother and then returning back to California. And so that is a realistic visitation schedule. So looking back at the Ramirez-Barker factors, it's our position that the trial court considered all of the factors that arose on the evidence, and that within its discretion, it determined that it was in Mila's best interest to move to California. Again, it's the critical comparison of what's going on in California, what type of activities is Mila going to be allowed to participate in, as compared to what's going on in North Carolina. Is Mila going to be able to leave daycare, or is she going to spend 60 hours a week in daycare? And within its wide discretion, the trial court appropriately concluded that the best interest of the child favored a relocation to California. I want to touch on one other argument that kind of runs through Cassie's brief, and that's that there is a suggestion, I believe it's on page 20, maybe 17 through 20 of the brief, that Isaac should be required to move back to North Carolina. I want to make abundantly clear that this court has said that district courts do not have the power to order one parent to move or to relocate. That's in the Pinellas case that we cited in our memorandum of additional authorities. The district court did what it was supposed to do. It took Isaac as it found him in California and then determined what was in Mila's best interest, and it appropriately awarded Isaac permanent physical custody of Mila. If there are no further questions, I'd be happy to take them, but we would ask that this court affirm the trial court's order.
All right, thank you, counsel. Any rebuttal?
Yes, Judge Deeds. So first, regarding, I think it's somewhat disingenuous for Mr. Munoz to contend at this point that the trial court's decision was not based on Ms. Munoz's military service. And if you look at what he actually testified about at trial, and this is on page 63 of the transcript, and it's also quoted in the brief, but in the transcript on page 63, he's under cross-examination by Ms. Munoz's counsel. And the question is, beginning on line 10, do you feel that because of her military service, she's not fit for primary care of the child? And his response is, that's correct. So there, and if you go through the transcript, if you look at the trial court's findings, there were no negative findings of fact about Ms. Munoz and her ability to be a parent. And Judge Wood, you pointed out that there was a finding of fact in paragraph 28 about her deployment. And if you look at some of the other findings of fact that were made by the court, paragraph 4, 27, 28, 41, and 46, the court references her military service, her past deployments, the fact that she was scheduled to be deployed at the time the temporary order was entered, and the potential for future deployment or reassignment over and over again. So it's clear that that was a significant factor in the court's decision. And I think that this situation that you have before you is exactly what subsection F was intended to prevent, where you have two people who are otherwise good parents who the trial court has no criticism of in terms of their parenting ability. And one parent loses custody because of the possibility of deployment and because of military service. And I think that if the court affirms the trial court's order, the precedent that it will set in this case is that subsection F will be essentially meaningless, because what the trial court focused on in this case is almost exclusively her deployment. There were two things that the court focused on. It was her deployment, her military service obligations, and the support system and childcare available to Mr. Munoz with his family in California. And subsection F, I believe, says that that the trial court cannot use Ms. Munoz's deployments and past and future as a basis for awarding custody to the opposing party. And I believe what this court has decided in Toole and other cases is that the finding that there is a support system that provides for childcare alone is not sufficient to warrant a relocation, not sufficient to meet the court's requirements of comparing the opportunities available to a child in each of the states. So based on those things, Your Honors, we asked for you to reverse and remand the trial court's order. And if there are no further questions, then I will conclude at this point.
All right, thank you, counsel. We'll adjourn. Mr. Soar?
Yes, Your Honor. This session of the North Carolina Court of Appeals is adjourned.
All right. Well, thank you both for your arguments. You're free to drop off now. It's like virtually walking out of that courtroom. So thank you.
Thank you.
Thank you.
Thank you both.